Thank you for joining us for the American Bar Association's Civil Rights and Social Justice program called How Things Work, the Legal Edition. How Things Work is a rapid response series examining how our civil rights are being affected by current federal actions. I'm Gary Rhoades from the editorial board of the ABA's Human Rights Magazine, and I'm very pleased to welcome you to this conversation. Now, this short video and the others like it in our series are a chance to discuss the complex changes happening in America today. They're also a chance to clarify any misinformation and especially disinformation that's being spread. They're also a chance to highlight ways that civil rights and social justice attorneys and advocates can act to better protect the rights of everyone. Now, today's topic, fair housing and the fight against housing discrimination, could not be more critical as we look at and confront recent federal actions to adversely affect fair housing enforcement and funding. It's essential to look at how these changes intersect with the principles of justice and equity. In context, the Civil Rights Act of 1968, also known as the Fair Housing Act, and the last landmark law that Dr. King worked on, remains the core federal law that protects us from housing discrimination today. Now, on that note, we are very honored to have with us attorney Robert Hunter from the esteemed law firm of Relman Colfax in Washington, D.C. Robert and his colleagues represent several fair housing organizations, and their firm has led the fight in the courts against housing discrimination for over 3 decades. This year, they are fighting to protect essential fair housing enforcement tools, such as the Fair Housing Initiatives Program, FHIP, or FHIP as it's known. And FHIP is administered by the U.S. Department of Housing and Urban Development, also known as HUD. Robert, we're grateful to have you here to talk about the legal landscape. I know that the FHIP program has been funded for the past several years at $86 million. And for as long as I can remember, FHIP has gone hand in hand with bolstering enforcement under the Fair Housing Act. Could you begin by describing FHIP and telling us about the types of work that the program funds?
Yes, and thanks so much for having me. FHIP is a long-standing federal grant program that provides the foundation for Fair Housing Act enforcement in many parts of the country. Since the act was passed in 1968, local nonprofits have taken on a huge amount of responsibility for investigating housing discrimination complaints and either filing lawsuits or complaints with HUD alleging discrimination. By the late 80s, the Reagan administration and Congress recognized that these organizations needed more money for the work that they were doing and created a trial program to help provide funding these organizations. That program was a success and grew into the FHIP program that we know today, which was codified into law in the early 90s. Through FHIP, HUD provides grants to fair housing nonprofits that process thousands of housing discrimination complaints every year and bring lawsuits and administrative complaints for enforcement. But they also do much more than that. Many of the organizations provide counseling services for prospective homeowners, help people with disabilities advocate for reasonable accommodations in their housing, and educate industry actors to prevent housing discrimination before it starts. And in many parts of the country, these FHIP-funded organizations are the only groups that are doing work in their area. One of our firm's clients, the Intermountain Fair Housing Council, is the only group in many counties of Idaho that does any sort of fair housing or eviction defense services. So the program benefits individuals. It also really benefits HUD, I think, by being this filtering mechanism to really identify meritorious housing discrimination complaints and allowing the agency to put its enforcement resources, deploy them more efficiently.
Well, I can definitely attest to the efficient and effective work of FHIP FHIP organizations. The trouble began in February of this year when HUD, along with the Department of Government Efficiency, known as DOGE, abruptly terminated 78 FHIP grants, existing FHIP grants, effective immediately and with no prior notice to the grantees. I was at a fair housing conference when this news broke, and it was just a shocking moment. And there were some layoff notices going out. What explanation did the administration give for this sudden and mass termination?
Well, initially, there was no real substantive explanation at all. The organizations each received a form termination notice that stated that the particular grant at issue was being terminated at the direction of the Department of Government Efficiency, with the explanation that it no longer effectuated program goals or agency priorities. That's it. There was no attempt to explain what that meant or how the Department of Government Efficiency might have authority to provide HUD with that sort of direction to terminate the grants. In the wake of this, our firm filed a class action complaint to challenge this action, representing 4 FHIP-funded organizations. And in that litigation, HUD has more recently taken the position that these terminations were done to align with various executive orders that were issued in the first months of the Trump administration. So their view is that there might be language in the awards that furthers what the administration views to be illegal DEI or similar concepts. Now, setting aside that that is an explanation that came out once the grant terminations had already been issued, it doesn't do a lot to clarify the substance of what's going on here, because those executive orders don't really define the contours of what the administration believes is illegal DEI. And so it puts organizations in a really difficult place, because they're kind of left to guess exactly what parts of their grant agreements or something else might have really been objectionable to the government here.
Could you walk us through the structure and policy chain here, including the executive orders themselves, subsequent internal agency responses or guidelines, and then I guess the DOGE reviews too?
Sure. So the basic structure of what happened here can be seen in a number of the mass grant terminations that we've seen over the past year. And you can think of it as sort of a 3-tiered process with 3 distinct actions by the executive government at different times. So first, there's the executive orders, and that is something that lays out the Trump administration's policy goals at a high level of generality. So these will often make sweeping statements about the law and the administration's policy priorities, sometimes with not a lot of factual or legal support. But these executive orders in and of themselves typically don't have the force of law. Instead, what they're doing is setting forth the policy priorities and instructing agencies to take some sort of actions at the agency level to implement the policy priorities. So that's the first level. The second level is at the level of the agencies themselves will design and execute some sort of policy to implement whatever the executive order is sort of asking them to do. So in some cases, this is a more formal rulemaking process or agency directive. It could be a more informal agency guidance. And in some cases, it can be what looks to be a kind of unwritten policy. And so in the case of these HUD cuts, there's clearly some sort of review that was taken in partnership with folks at DOGE, but we're still not exactly sure the exact contours of what that policy was. But that's sort of the second level where the agencies are trying to execute the policy priorities that are set forth in these executive orders. And then the third level is the actual application of those policies to grantees. So in this case, the actual grant terminations themselves, that piece of paper that says no longer effectuates program goals of agency priorities. And it's that third level at which the organizations, the private actors have to figure out what this all means and unpack the significance for their operations.
Yeah. Um, has our federal government ever taken action like this before against an enforcement agency, especially a long-standing enforcement agency like this?
No, we're not aware of anything like this happening before. Typically, there's a fairly specific process that's followed for any attempt to terminate a grant, and it would usually only be done on a very case-by-case basis if there's some sort of specific allegation of non-compliance with the grant terms or some sort of material condition, non-performance, something like that. This is the first we have ever seen of HUD really trying to do this on a mass scale and without those particularized findings regarding each of the organizations. And it was really shocking for the organizations for that reason. Within just a few days of that termination decision, many of those groups had to stop providing critical housing services. In the temporary restraining order application that we filed in that case, we note that many organizations had already begun layoffs within just a couple of weeks, and some of the organizations have now stopped operations altogether. Just to give one example, one of the plaintiff organizations had received an intake from a woman who was a survivor of domestic violence and believed she was experiencing discrimination in her shelter. Because of the grant cuts, the organization was not able to take on that case, advocate for her, and it puts this person at an increased risk of living on the streets. So the impacts of this are real and they're devastating. The other thing that has been unprecedented here was HUD's delay in announcing FHIP awards for this past fiscal year, the 2024 fiscal year, which just ended in at the end of September. Typically, what would happen would be announcement for the grant awards are announced in the fall of a calendar year. Recipients are announced that next spring, and there's a couple months for the organizations to, negotiate all of the paperwork, start work with no gap in funding by the end of the fiscal year. That didn't happen this year, and in June of 2025, our firm represented fair housing groups that were impacted by this delay in funding because they're unable to sort of plan for the next year's operations, not sure what's going to happen with this money that they had applied for. And we were able to secure an injunction in July instructing HUD to make sure these funds were obligated by the end of the fiscal year in September.
Congratulations on that.
Thanks.
What are the legal limits on the administration's ability to make a policy like this by administrative action?
Sure. So it's going to depend somewhat on the context of the specific administrative action because there's different rules that apply to different types. But one principle that's going to be consistent throughout is that a executive order or a sort of decision or policy regarding a grant termination cannot conflict with an existing statute or the Constitution. And that includes binding interpretations by a court of a statute or constitution. So a president or an agency may have the authority to set certain enforcement priorities, but they can't just unilaterally say that conduct they don't like is illegal via an executive order. Um, as we've seen in the FHIP context, this matters because there's often very specific requirements set forth in the statute authorizing a grant, or maybe regulations with the force of law about how that grant needs to be administered. Those can't be unilaterally changed.
You've mentioned the injunction. What is the status, the overall status of the litigation now?
Sure. So in the February 2025 termination case, we are awaiting a decision from the First Circuit Court of Appeals that will affect whether those claims will continue in federal court or proceed in the Court of Federal Claims, which is sort of a specialized federal court that deals a lot with contract disputes with the government. That's a complicated jurisdictional issue that we could have a whole nother program on. So I'll just say for now that we're waiting to hear from the court on that issue. In the second case about HUD's delay with 2024 fiscal year funds, there was a temporary restraining order granted in July, which was converted to a preliminary injunction. That is still in place, and consistent with that injunction, HUD put out new requests for funding opportunities. Organizations applied for those funds in August, and those funds were awarded just this September at the end of the fiscal year. So as we're recording right now, there's a government shutdown in place, but we expect that as soon as that is up and running again, organizations will be working with HUD to finalize their grant agreements, get that money out, and start work on the grants.
Um, well, Robert, before we conclude, I have to ask you another burning fair housing question. The Trump administration is challenging the use of disparate impact analysis in fair housing cases, and that's something that we were all breathed a sigh of relief back in 2015 when the Supreme Court affirmed the use of disparate impact in fair housing cases. Your firm recently published its analysis of the importance of that type of tool and theory of liability, and it also your analysis went into the danger that it's now in. Could you remind viewers of what disparate impact analysis is and how it stands in 2025?
Of course. Disparate impact is a long recognized theory of liability under the Fair Housing Act and also exists under several other federal statutes. It means that under the Fair Housing Act, even actions that may appear to be non-discriminatory in their face, but that do have a unnecessary negative impact on a protected group, either people who share a certain race or gender, for example, are unlawful unless there's essentially a legitimate reason for that disparate impact. And that part is key here because a defendant won't be found liable under disparate impact theory if they can show that there's either a legitimate business need for the policy causing that impact, or there are no less discriminatory alternatives. And so by definition, the liability is only attaching when essentially there's no good reason for it. And it's a very common sense fairness principle. And it's also not new. It's been enshrined in statutes and regulations and applied by courts for years. In April, the Trump administration issued an executive order that purported to call into question the constitutionality of disparate impact doctrine, instructed agencies to deprioritize those enforcement actions, and HUD has been preparing a new rule on disparate impact, but as of the time of this recording, we don't know exactly what that rule will say. But the bottom line is really what we discussed earlier about executive orders not being able to change the law of the land. Disparate impact has been recognized by the Supreme Court It derives from the text of the Fair Housing Act, and it cannot be unilaterally overturned by the executive branch. HUD may be able to control whether they actively pursue cases using that theory, but that doesn't make it illegal, and private actors or state attorneys general can still pursue those cases.
Thank you, Robert, for a clear walkthrough of what's happened and its impact on fair and equal housing. To everyone watching, this critical work never stops. It continues in the actions we take in our communities, in the courts, and here at the ABA. I encourage you to stay engaged with the American Bar Association, especially its civil rights and social justice section. Check out our webpage, explore upcoming events, and consider joining a committee that helps shape this work. Thank you again for watching. Keep fighting. Together, we can and will make a difference.